What kind of disputes between the government and employees have to be arbitrated? To find out, you have to read City of Yonkers versus Yonkers Firefighters. It's only 5 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases, the episode on City of Yonkers versus Yonkers Firefighters, found at New York Slip Opinion 07095, published on December 15th, 2022. This is a civil case. The issue here is whether a certain dispute, a grievance between a public sector union and a city is subject to mandatory arbitration or not. The facts here are basically the city of Yonkers had an agreement. They were paying special pay under General Municipal Law 207 to firefighters to make up the difference between pension benefits and regular pay, or disability benefits and regular pay. And then they decided to stop doing that. So the union made a grievance, filed a grievance with the city and the fire department saying you can't do that. And the city refused to change their policy. So the union filed a petition with the court saying, pursuant to the terms of our collective bargaining agreement, we want mandatory court-ordered arbitration of our grievance. The trial court denied that application. The appellate division agreed with the trial court and it went to the Court of Appeals. Now, to properly understand what's going on here, I think it's important to step back. There's a sort of a history here. In 1977, there was a case called Liverpool that is, and you can find that at 42 New York 2nd 509. It's a Court of Appeals case, where they established a two-step test to determine whether an agreement could be arbitrable, or could be subject to court-ordered arbitration based upon these two steps. The first they called the may they do so test. The first one looks at the subject matter of the grievance. Is this subject matter based upon public policy, based upon constitutional considerations? Is this a proper subject matter to be resolved at an arbitration? And the second step is, did they do so? So it's may they do so? Did they do so? Did they do so says, let's look at the arbitration agreement. Let's look at the terms that the parties agreed upon in the collective bargaining agreement and see if they both agreed to discuss and address this particular kind of dispute at arbitration if they have to, if they can't agree upon it. So that was 1977 in the Liverpool case. In 1999, there was a landmark case in the Court of Appeals called Board of Education versus Watertown. And that case can be found at 93 New York 2nd 138. And in that case, they applied the Liverpool test, but they clarified the second step. The second step, they said, the first step is still valid. May they do so? The second step says, though, the merits are irrelevant to the court. The court should not look at the merits, whether the grievance should be upheld or not. That's the job for the arbitrator. And the second clarification they made was that instead of it being specifically described in the collective bargaining agreement, they said if there's a reasonable relationship, it's the reasonable relationship test. It doesn't have to be specifically described and defined in the CBA. If there's a reasonable relationship between the grievance, the subject of the grievance, and the subjects addressed in the CBA and the collective bargaining agreement, then it's arbitratable. So now let's talk about our instant case. Here, they go through the process. They say that Board of Education test still applies. They go through the subject matter. They say, obviously, the subject matter is appropriate for arbitration. And when they go to the second one, they say, okay, maybe it's not exactly specified in the CBA that this is the exact kind of thing that they discussed in the CBA being arbitrated, but based upon the reasonable relationship test, which is, essentially they discussed payment in the CBA and benefits in the CBA, and the grievance here is about payments and benefits. And they say, based upon this reasonable relationship between the grievance here, which is the city stopping special payments, and the terms of the CBA, which discusses payments and benefits, the court should have permitted and ordered that the arbitration take place. So they overrule the appellate division and the trial court, and they say this is subject to mandatory arbitration pursuant to the terms of the CBA. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.